Hi, I'm Reed Bloodworth, the managing partner of Bloodworth Law, with offices located in Orlando, Florida and Winter Haven, Florida. We handle probate disputes throughout the state, from Tampa to Daytona, Miami to Pensacola. Today, I'd like to talk to you about what is required for the proper execution of a will in Florida. There are 4 primary requirements that must be satisfied in order to have a valid will in the state of Florida. These requirements are: 1. The will must be in writing. 2. A properly executed will has to be signed by the testator, the person making the will, or by another person at the testator's direction and in the presence of the testator. 3. The will must be signed at the end by the testator or another person at the testator's direction. And finally, a will must be signed in the presence of 2 witnesses who have to sign in the presence of each other and the testator. If these requirements are followed, then a valid Florida will is created. However, if you wish to create a self-proving will, which makes getting the will admitted to probate easier, an additional step is required. In order to create a self-proving will, the testator and the witnesses must sign in the presence of a notary, and the notary will then notarize the signatures on the will. Beneficiaries usually don't know the contents of a loved one's will until after death, when the document is shared with family members during probate administration. Family members can be surprised, hurt, shocked, or feel that some items were not properly passed down, or that issues were not carried out the way that a loved one would have wanted. There may be strangers named as beneficiaries. Whatever the reason, a review of the will may bring up questions of validity, and the execution may prove to be invalid. A probate litigation attorney can assist you in finding answers you have regarding a loved one's will, including whether or not the will was properly executed. Usually, the testimony of eyewitnesses to the will execution will be heard. Other reasons for questioning the will may include a lack of capacity. This requires that the testator was of sound mind when the will was executed, that they were not under medication that altered their judgment or suffered from something like dementia or Alzheimer's. Undue influence. It's a claim which the testator was controlled or persuaded by outside influences. Another is fraud, which includes that testator was misled into signing a document believing it was something else. Finally, duress, which involves a threat of physical harm or significant pressure to sign the will. If you believe that a will was improperly executed or that there are other issues with a will, you must act quickly. Florida has a very short statute of limitations in which to challenge a will, potentially as short as 20 days. If you have questions surrounding the execution of a will, talk to an attorney. Decide how to resolve what you believe to be improper actions. While we're located in Central Florida, our team travels across the state. We go to our clients so that we can handle the most interesting cases. Again, I'm attorney Reed Bloodworth, the managing partner of Bloodworth Law. If you have issues relating to a will or probate dispute, give me a call. Let's talk about how Bloodworth Law can help you or your family.